Okay, we are now recording. It is Friday, April 16th. We are 2 minutes late for starting, so I'll be very quick. Guys, I am thrilled today to, first of all, administratively, we're up to 7,200 people, actually more than that now. Thank you everyone for their continued support. Other thing that I always say in these things, despite the fact that our group is private, these lectures are public. These are posted on public forum. Anything you say is being recorded. Be advised of that fact. We are thrilled today to have Wesley Jackson with us. Wesley is a lawyer out in the Brampton, Oakville area, but he's much more than that. Real estate lawyers are really a dime a dozen, and I'm not trying to negate what a real estate lawyer does. I do this professionally, but there's all sorts of lawyers out there. And then there are those lawyers who really are the leading lights of our profession, who understand the ins and outs of what the nuances of the law are, and who are able to advise other lawyers looking for guidance as to the right way to act, conduct themselves, and to conduct law. Wesley is definitely in that latter group. Wesley stands out for his online work, which many of us regularly see on our forum, on the lawyers' forums and others. His answers are always well-researched, have an element of humor, which make them enjoyable, but above all else are correct. And to that end, we are privileged to have Wesley with us today. He will tell you a bit about his business, and then he's going to launch right into what we all want to hear about, which is off-title searching and illegal basement apartments. Enough with my voice. Wesley, over to you.
Thank you. You've oversold me a little bit. We have many esteemed lawyers and certainly some realtors who have been doing this longer than I have and know more than I do. So please do not use this against me in a court of law. If you'll indulge a brief introduction, I've been practicing in Brampton since 2003, and I began at a full service firm, meaning that the firm did everything from criminal law, civil litigation, estates, real estate. And as a junior, I got involved in all of it. And it's a background that's given me a very practical, some might even say cynical, approach to issues in real estate. Always grounded in law, but always with an equal eye on the laws of what I like to call natural justice, because that's what judges are often motivated by, far more than a poorly worded Schedule A clause. And what do I mean by the laws of natural justice? You know, these are the laws that every single one of us knew from the day we were born, and I can prove you knew them. See if this exchange sounds familiar. Hey, get off, that's my swing. Your name's not on it. Raise a hand if that rings a bell from the schoolyard. Of course it does. We were all born knowing that law. Your name's not on it. Well, guess what? You understand registered chain of title. You also fully understand, since the time you were 6 years old, the corollary law. Possession, my friend, is 9/10 of the law. I'm on the swing, it's my swing. The third thing that we've all known since we were 6 years old is that sometimes it's not about who's right or who's wrong, but who has the biggest big brother to enforce your rights. In other words, I don't care if you're on the swing, it's my swing. And by the way, my big brother's over there to encourage you to give it back. And so we've all known this little thing. Give me back my G.I. Joe or else. Or else what? What are you going to do about it? And that's why I say I'm always grounded in that reality. And this has come up in a lot of the online discussions. You know, who's right, who's wrong? Well, quite frankly, when you're about to pay up a $10,000 retainer to a litigation lawyer, who cares who's right or wrong about a $2,000 water bill? You settle it, you move on. It's not always about who's right or who's wrong. It's about who has the biggest retainer to deal with it in court. And the answer is nobody. Nobody wants to go to court. No one wants to give more money to lawyers. Lawyers are the least popular piece of this equation. So now that we've all established that we all understand registered chain of title, and we all understand that it's often about enforcing your rights as opposed to having rights, let's talk about the grown-up version. Let's talk about real estate. And why is it important to understand in real estate the distinction between title and off title? And what is even off title? Well, roughly speaking, lawyers have divided all of creation into two categories: personalty and realty. You're all on personalty right now: your computer, your clothes, your chair. These are all personal possessions. And other than the PPSA system, the government doesn't really get involved. You go to Best Buy, you buy a DVD player, it's your DVD player. The government doesn't really care. Your car they care about, they'll keep track of that, but only when you borrow money against it. That's when we get into PPSA registration and registered leases. But real estate is entirely different. Real estate, because it's fixed, because it's permanent, it actually is capable of acting as an anchor to very complex legal structures and legal relationships. Bear in mind, if you remember your high school math, trigonometry and all that stuff, when you own land, you own everything from a singular point at the core of the earth, outward like a triangle, out into the universe. You own all your subsurface rights and you own all your air rights. And because of that, lenders can count on it being there. Even if the house burns down, the land is still there. They can take possession of the land, they can resell it. So now we're into lending relationships. Owners can count on it as a place to sleep, whether you're in a tent, a trailer, or a brick and mortar home. And as soon as you have a house, again, you're back into lending, you're into security, you're into safety, all these fundamentals on the hierarchy of needs. So land in our society occupies this very, very complex place, and we take a lot of it for granted. But, why am I talking about the center of the earth? Well, how do you think your utilities get from the street to your house? They go underground. And in order to run that pipe underground, it's land that you own, the region, Hydro One, whoever it is, they need access to your property, and they have to have the right to come in and dig a trench. Well, it's your land. You can't sue Hydro One for trespass every time they come and read your meter. So again, these layers and layers of really rather sophisticated legal relationships that we all take for granted because they're part of everyday life. So how do you buy or sell something so complicated, something so sophisticated? That's where the lawyers come in. That's where the agents come in. We understand all this stuff so that our clients don't have to. But what the government, and we used to have the registry system, which was a lot more complicated. The government has simplified what the government wants to get involved in. What the government is involved in and what they want to be involved in, increasingly less so under Jeffrey Lamb, is registered ownership. The registry office, the land titles office, doesn't even want to know about trusts anymore. Just who's the owner. And the government will keep track of that. And so title searches are relatively easy. I'm not going to do a lot of screen sharing today, but I just want to show you very, very quickly, if I can find it here. I can't find it. Sorry, technical glitch, can't find it. You're all familiar, lawyers, with parcel abstracts, geo warehouse, whatever. You can see the chain of title. You can see the builder bought it from the farmer. The builder put up 40 houses. Now Wesley Jackson bought it. And that's relatively easy to ascertain. But what about off title? What is that all about? Well, it's all the things that the government can't or won't register on the land title system. And your name's not on it is a valid argument, but it's not a complete argument. And so I want to start, and first I'm going to recognize title insurance covers a lot of the off title stuff. But ask yourself the question, would you rather be insured in a car accident or not in a car accident at all. And so obviously you don't want to be in the car accident. So title insurance is not a complete answer. And I'm going to illustrate this with my own personal war story. The first house I bought was built in 1920. We bought it in 2005. Now in 1920, when they built this thing, it would have had a 4-foot basement. When we bought it, it had a 7-foot basement. Well, guess what the Brampton MacGyver didn't know about lowering a basement floor? Raise your hand if you guess that you need to put a foundation underneath your support posts. He did not know that. And so what happened to my house? It sunk into the ground like a nail, and it took the floor with it like this, to the point where you could see the bow in the floor with the naked eye. How is this an off-title search? Well, because if the city of Brampton had come along and seen that, they could have issued me a work order to fix it, because that house will eventually fall down and be unsafe. Well, how the hell's a lawyer going to find that? This is where, agents come in. This is where reading past MLS listings come in. This is where knowing something about the history of the neighborhood, a history of a house comes in. A client of mine was buying a house in Niagara Falls, and I looked at the last MLS listing, and this came up because on the title search, it was clear that the vendor had bought this thing about 4 months before they sold it, and they had bought it for over $100,000 less than they were selling it for. So clearly they had flipped it. So I send the requisition letter. Hey, send us your closed building permit, send us your occupancy permit, send us your fire and electrical inspections. And like all lawyers do, he wrote back and told me to satisfy myself. Well, that's great, counsel. I'm happy to phone the building department and satisfy myself. I'm happy to phone the fire department and ESA and satisfy myself. Are you sure that's the next phone call you want me to make? Or would your client like to sign the mutual release because you did all that work without a permit? So you always have to be aware of what's at risk and how you might be able to find out about it. In 2020, 29% of claims against lawyers related to lack of adequate or competent investigation. This is anything from not reading or misreading a survey, failure to ensure a buyer actually has access to a property, failure to review status certificates for condos, failure to ensure condo or parking spots or lockers are actually for sale or actually owned, failure to review powers of attorney for legality, conformity, and validity of use, failure to look out for frauds, and failure, and this is important, to confirm the intended future use of the property. Because adequate investigations that involve title and off-title searches and how you write the agreement of purchase and sale need to reflect what the buyer wants to do with the property in the future. I'm going to refer to basement apartments, and I'm going to use it as a lens, but I could easily use the first season of Homes on Homes as a lens. I could use my own house as a lens. It ultimately boils down to the same core issue. Houses are more than just a chain of legal title. They're physical things that people own and do unimaginable things to. Tearing out plumbing, tearing out electrical. It all happens and nobody's paying any attention. And you can really buy a fire trap, a death trap. You can fire something, you can buy something that, like I did, is sinking into the ground. One of the things we found when we were fixing our foundation was they had moved the gas stove from the left side of the kitchen to the right side of the kitchen. Well, what they didn't do was strap any of the gas pipes to any part of the house. So where they had capped off the gas pipe was sitting in the dirt. And it was wet and it was rusty. And if we hadn't gone in to fix the foundation, our gas fitter was just like, yeah, it was just a matter of time before your house blew up. So it's very easy to say, oh, yeah. A survey if you have one, but if you don't have one, don't worry about it. But how else are you going to know that the kitchen is in an addition that wasn't originally part of the house? Either as an agent, you know the neighborhood well enough to say, yeah, this house was built in the 50s and that's not the shape of the original house, or your house inspector picks up on it. Or you do off-title searches. You search the building department. You search for the original plans. And if you never ask your client, what do you plan to do with this house? How are you going to know that they want to put in a basement apartment? How's the lawyer going to know? How am I going to know to search the setback requirements and the side yard lot size requirements? And most importantly, how do I get my client out of a deal that's not contingent on those things being true? I can't. There's nothing I can do about it. At the end of the day, it's not about getting a deal done at all costs. It's about protecting your client and making sure your clients are getting what they're paying for, especially as the average price of houses in the GTA is hitting the $1 million mark. Very early in my career, we got a call. Guy had bought a house and he bought it, and it was about 6 months after closing, and he called. He was quite upset. He says, look, I just found out we're not going to be able to put a pool in our backyard. I said, well, our litigation department will happily take that on, and we'll ask some questions of the realtor and the lawyer involved. Let's have a look at your agreement of purchase and sale. Well, I'm sorry, sir, it doesn't say anything in here about you putting in a pool. Did you tell your agent you wanted to put in a pool one day? No. Did you tell your lawyer you wanted to put a pool in one day? No. Well, the agreement's not conditional on you being able to put in a pool one day. True. But I still want to sue someone because I'm very upset, because now we have to sell our house and go buy a new one where we can put in a pool. I didn't take on the case. I'm not going to sue somebody on that basis. But at the end of the day, they would be able to advance a claim, win, lose, or draw. Someone's going to spend a lot of money on legal fees trying to figure out whether or not the agent and the lawyer satisfied the duty of care by asking, what did you intend to do with this property? And if the client just didn't tell you and you asked, you're safe. But if you just didn't ask, you face a potential claim. And you may win it, you may not. It's still a potential claim, and it's something that you need to worry about. Like I say, 29% of claims against lawyers for inadequate investigation. And that's what this type of claim would have fallen in under had that buyer pursued it. So what does all this have to do with basement apartments? Well, basement apartments are basically all of these issues wrapped into one. It's zoning, it's bylaw, it's unpermitted construction. And when I say unpermitted, I don't mean unallowed. I mean, it's done without a permit. Like I say, I've been practicing in Brampton since 2003. If there's a city that is rife with illegal basement apartments, it is Brampton. And we all know the code. Vendor does not warrant retrofit status, wink, wink, nudge, nudge. In other words, vendor is admitting that this is not a legal basement apartment, buy it anyway. But the basic reality is willful blindness is not a defense. So if you know that there's a basement apartment and you know that it's not legal, it's certainly excluded from title insurance. And so when a buyer is upset and it's not insured, they're going to look for a different pocket to pick, because that's the nature of litigation. Looking for a pocket to pick to make somebody else happy. And so we search. We search the building department for open permits and work orders. And that can be, we have single tier municipalities. We have like Brampton we have a municipal and a regional government. We look for work orders from fire departments, electrical safety authorities, tax departments. We can do bankruptcy and insolvency searches. I can't tell you the nightmare that arises when a homeowner declares bankruptcy and a bankruptcy trustee takes title after the agreement of purchase and sale has been signed. You can do litigation searches. You can find out if your vendor is currently in court. Now, that may not come up on a residential transaction, but can certainly come up in commercial transactions. Transactions which are fraudulent can be reviewed for up to 5 years under the Fraudulent Conveyances Act. If a property sounds too good to be true, like you think it's a $2 million property, it's being sold for $1 million, maybe not your client, but maybe the transaction immediately before yours, maybe that was a fraudulent conveyance. Maybe you have to look that up. Maybe you have to look into why somebody got such a sweetheart deal. If there's tenants, what about litigation in the rental housing tribunal? The last thing your buyer wants to do is take on 5 tenants just to find out that they have a hearing next week. You want estoppel certificates from tenants. You want to inspect rent rolls. Corporate records need to be searched. Corporations which are canceled, that property now belongs to the government. 123 Ontario Inc. can't sell a property if it, you actually have to bring a private member's bill to restore that company so that company can deal with the land. Zoning and bylaw searches, residency searches, which are predominantly done by way of affidavit. But if you have reason to believe that an affidavit is not valid, you can't accept it as a buyer's lawyer. Capacity, estates, and power of attorney issues can often involve searches. Construction Act issues, land use restrictions, environmental risks. Buying land beside there's an apartment building. My sister lived in an apartment building in Barrie. It burned down because the dry cleaner caught fire. Well, dry cleaning chemicals can contaminate land. So if you're trying to sell the house beside the condo that burned down because the dry cleaner burned down, are you worried about environmental risks? Or are you worried about, all throughout the Oak Ridges moraine, how many deals have fallen apart when people find out they can't build a second building, or they can't move the house, or they can't expand the house because of greenbelt protections and environmental protections? Fraud in the chain of title is an off-title search. Errors in government records. Google Brampton's Big Blue House to see what can happen if there's an error in government records. That can, imagine that Big Blue House got built. I mean, I see some people shaking their head because they know the story. Imagine you bought that house off the guy who built it, and then the city realized they issued a permit under the wrong bylaw and told you to tear it down. That's a title insurance one for sure, but that's a problem. What about property stigmas? Some people could care less that this used to be a marijuana grow op, or that there was a suicide, or that there was a murder. But suicides, murders, and grow ops happen. Does your client care? Did you ask if they care? Did you search? And if you're just willfully blind and you don't search, and you never have a discussion, you can find yourself on the receiving end of loss of business reputation. If lawsuits in extreme cases, it can be a nightmare. And again, coming back to basement apartments, the number one thing that the city is concerned with, that the government is concerned with, that we're concerned with in this industry, is construction done without a permit. How many times are we going to read that somebody died in a house fire in an illegal basement apartment that wasn't built to code, didn't have 2 exits, didn't have fire suppression equipment, didn't even have detectors for carbon monoxide and fire? When you turned a blind eye to unpermitted construction, you're really gambling your deductible, your E&O deductible. And for what? Like I say, you cannot rewire a house without a permit. You cannot replumb a house without a permit. And basement apartments, 99% of the time, involve both of those things at a minimum. And so when you see those magic words, does not warrant retrofit, be aware that someone is asking you to potentially rebuild their basement apartment for them when it turns out that the city comes along and issues a work order. So on every transaction, take it back up to the general level. Lawyers, buyers, all have to use their judgment to determine which searches are a good use of time and money and what can be left to title insurance. And how do we do that again? What's the present use? What's the future intended use? Those are the two biggest questions. 9 times out of 10, a Brampton townhouse is single family residential. You're not going to spend a lot of time worrying about that. You're going to title insure it and you're going to move on. I mean, what's the worst that's going to happen? The guy was running an illegal business out of his garage. Well, once the vendor's gone, the city's going to lose interest and title insurance is going to mop up the mess. It's really not that big a deal to opt for title insurance over extensive off-title searches that may not actually reveal the issue anyway. Excuse me. But if you know for a fact that businesses are being run out of somebody's residential house in single family residential, and it's not allowed by the zoning, maybe you want to make a soft inquiry to the city. Are there any ongoing prosecutions? And we'll get an indemnity from the vendor, and we'll make sure that our buyer client is completely segregated and that it won't come back to haunt the buyer. A little bit of due diligence, you get your client the protection that they need. In terms of future use, I encourage everybody to refresh their memory on the wording of Section 8 of the OREA form of agreement. I'm talking about resale. The buyer is entitled to search for title issues and ensure present use blank may be lawfully continued. The most common entry that I see in that is residential. And that can be very, very problematic because residential includes single family residential, but it also includes multiple dwelling units. I mean, both of those things in theory are residential. So what is it you're asking the vendor to represent? How are you protecting your clients? Whether you act for the vendor or the purchaser, you have to be careful about what you put there. And when you're acting for the buyer, is your client's plan actually to take the use of the property as is, where is forever, or do they have something in mind? Do they plan to put on an addition? Do they plan to put in a basement apartment? Because unless the plan is as is, where is forever, you're really putting the lawyer behind the 8 ball when he's doing his searches. If there's nothing in Schedule A that talks about the intended future use of the property and things that may need to be changed in the future, it's very difficult to requisition evidence that I can put in a pool next year if it's not in the agreement of purchase and sale. So I harp on it, but it is important. Intended future use. What is and what is not relevant to a transaction is all in the agreement of purchase and sale. And so you have to draft it properly. And when lawyers are asked to review an agreement of purchase and sale before it firms up, we have to look very, very carefully. It's not just about checking to make sure that it's properly written. That is important. But does it accurately reflect the intention of the parties, both today and tomorrow? So I wanted to digress for a second. I sort of got a little bit out of order, as I tend to do when I'm talking. Things that go badly, okay? 2014 case, the McDonald's bought a house in Toronto that was badly renovated. The repairs cost $75,000. At trial, the title insurance company didn't have to pay for these costs. And one of the interesting things that Jeffrey Lem had to say about this, and this is why I like the commentary about this case. A toxic waste dump may be totally unmarketable, but you can have pristine title to it. I mean, think about that just for a minute. Now, the Supreme Court of Canada ultimately went back and overturned the trial decision on the basis that consumers should be protected, and that's why they bought title insurance, and those expectations need to be enforced. But the title insurance companies reacted to that by changing the way the title insurance is written. And so one of the acknowledgements my clients sign when it comes to title insurance is that this is title insurance. It's not physical insurance for the condition of the home. It's not prior renovation insurance. It's title insurance. So yeah, if there's a work order, the title insurance company has a role to play. But if your wall is sagging and it just needs repair, you're kind of on your own. I just need to grab a drink of water because my throat is very dry. Bear with me 1 second.
I'm just going to use this opportunity to plug one of our previous talks. Those of you who are interested in McDonald's case, we actually had Alex from Gardner Roberts, who actually fought that case up to the Supreme Court and talked to us about title insurance and what it covers and what it doesn't, and the changes since the McDonald case took place. So for those of you who want to find out a bit more about that, please feel free to search for that or any of our other video sessions under video sessions. If you took the hashtag video sessions, Facebook now actually takes hashtags. And the video session hashtag will show you, I think we have about 40 videos just like this one, dating back for the past year, which you can now watch to your heart's content. All right, back to Wes.
Sorry for that. I was going to choke on the dryness here. So finished basement. Sorry, this is the Shives case, 2018. It may have been covered in previous talks. I'm just going to touch on it very, very quickly. Mostly finished basement, drywall, ceiling tile, floor coverings. Mostly exterior perimeter walls in the basement were covered with drywall. The plaintiffs did plan to use the basement for additional bedrooms and or a family room. In 2013, they noticed a problem with the rear basement wall, begun to noticeably sag. I'm just trying to hit the highlights. Basically, huge cracks in the foundation. Title insurance didn't cover it. And again, what does that mean for off-title searching? Bob Aaron writes about this extensively. I'm sure it's been discussed extensively. You cannot underestimate the value of a survey. And where you don't have a survey, as an agent or as a lawyer, your knowledge of a neighborhood, I live in Peel Village and all those houses were built at roughly the same time. If my house doesn't look exactly like the house next door, which is the exact same model, somebody's put on an addition. And knowing that means that there's due diligence that needs to be done at some point in the chain of title. And whether it was done with a permit or without a permit, who knows? Clients of mine sold on English Street, and they had an addition on their house, and they had lived in the house for 10 years, and their buyers, when they sold, requisitioned open permits. And now these open permits had been there for over 15 years. And when they bought, they didn't use me. I tend not to work for friends and family because you never do a good job and you always charge too much. But their lawyer didn't search permits. They just title insured it. But these permits were open. And my friends, their buyers weren't going to title insure over it. They wanted those permits closed. They just weren't accepting title insurance as the answer. And so panic, chaos, 3 days of running back and forth to the city planning department, trying to get these 15-year-old permits that the city of Brampton couldn't even find closed. All that stress and aggravation. And all it did in the minds of my friends was anger them that their lawyer had screwed up, even though our insurance company would say, no, lawyer didn't do anything wrong. He title insured your transaction, and title insurance would have made sure that you didn't lose any money. Yeah, but who compensates me for my 3 days of running around? Who compensates me for the stress and aggravation of thinking that my sale's about to fall apart? Nobody. And so it goes above and beyond that standard of legal competence. Just because you aren't negligent doesn't mean you did a good job for your client, is really the lesson to be taken away from my friend Sean and Tara's problem. So there's other cases. I won't get into all of them. I'm talking too much. And I'm not a litigator, and I don't bring that kind of perspective to it. But a theme in all the cases, and this is going to sound familiar to anyone who does anything in real estate, work done without a permit is a latent defect. And it's one of those defects that cannot be found directly. I can't search for a permit that never existed. I write to the city, I say, any open permits? They say, nope, there's never been a permit. That doesn't mean that the work wasn't done. Obviously it was done. And so when it comes to basement apartments, we know that they're there. The buyers know that they're there. Sometimes the lawyers know that they're there, but the agents certainly do, because the agents went into the house with it. And so you have to start with a solid agreement of purchase and sale. And I hammer on this and I repeat that. And the solid agreement of purchase and sale starts with carefully reading for the code words in the listing. Newly refurbished kitchen, updated bathrooms. These are all things that are going to lead you to say, well, what do you mean by refurbished? Did you replumb the kitchen? Did you rewire it? When you say updated bathroom, how much of an update are we talking about? And if it's, oh, well, we painted and we put down some new tile, okay, great. I'll probably let title insurance clean that up. But if you know, because you've showed 10 houses in that neighborhood, that the bathrooms are typically 5x8 bathrooms, and this is a 10x16 bathroom, that they have substantially renovated that floor of their house to have this, beautiful ensuite that sold the house, fair enough. But that's your flag. That's where you put in the agreement of purchase and sale. Or you send a note to the lawyer, like, look, this was a substantial renovation. This needs to be looked into. Don't just title insure this one. Specifically, bringing it back to basement apartments, I just want to draw the distinction between, the term legal as it's used out on the street, because legal just means it's built to code. Legal means, yeah, I had a licensed electrician, but that doesn't mean that it's lawful and registered. And what you want when you're buying a house with a basement apartment or secondary suite of any kind, whether it's above the garage or in the basement, doesn't really matter. It's all the same thing. You want it lawful and you want it registered. Because the registration process means that everything was done properly up until that point. And so how do we turn that into what I like to call a solid agreement of purchase and sale? Well, importantly, representations and warranties are great. But do you know what's better than representations and warranties? Documents. The stuff that lawyers dream about at night. Mountains of paper. That's what you're looking for. And what you want your agreement of purchase and sale, I'm not going to give you the exact wording. I mean, word it however you and your broker want this worded. But your high watermark, your ideal agreement of purchase and sale, vendor shall furnish the issued occupancy permit, just like a builder does. When you've registered your basement apartment, the city is going to give you your occupancy permit, and there's documents you get from the city. Vendor, I'm buying your house with a basement apartment, give me that paperwork. Depending on the city that you're in, maybe it's vendor shall furnish a copy of the filed municipal registration documents together with copies of closed building permits, together with inspection reports concerning framing, plumbing, wiring, insulation, HVAC, fire, and municipal inspections within 10 days. And here's how you wrap it all up to protect your clients. Failing which, the agreement of purchase and sale is at an end and the deposit returned. That's how you protect your buyer client. Give me the documents, and if you can't give me the documents, I'm assuming this is an illegal basement apartment and we're walking away. And your legitimate basement apartment, built to code, fully licensed, fully permitted, your vendor is going to be like, yeah, I have a file on that. I spent a lot of money on that. Happy to show it to you. Just like you can buy a car that's a lemon, or you can buy a car that's been pristinely maintained, used I'm talking about. I've got a little folder with all my oil change receipts. I've got receipts for the new tires I put on, because if I ever sell my car, I want to be able to show that to a buyer to say, yeah, this is a well-maintained car. And what if your house doesn't have a basement apartment, but your client wants one? A client of mine sold in Malton. beautiful 4-bedroom house with a completely unfinished basement. Like we are talking original from when it was built. And an 8-foot side yard, meaning more than enough room to put in a side entrance to that basement. Great. We know that the buyer's going to go in there and build a basement apartment. We just know it. Absolutely no question that's what's happening next. The minute this place is sold, the trucks are coming in to start building. So again, representations and warranties are great, and vendors would be very, very wise not to sign a representation and warranty that a buyer is going to be able to put a basement apartment in. You have absolutely no way of knowing that. You have no way of knowing that City Council tomorrow morning isn't going to convene a meeting and ban basement apartments on your street. You can't control it, so don't sign it. Well, if the vendor's not going to sign it, what can a buyer do? Well, this is where conditions come in. And you're going to advise your client, CYA, 3 most important letters in the English language. You tell them you can't control the future, but you can control today. And what you want is you want a conditional. This offer is conditional upon the buyer being satisfied they will be able to install a basement or secondary unit. Or maybe it's a swimming pool, or maybe it's a 4-story addition or a roller coaster in the backyard. Doesn't matter. When it comes to future use, you want that condition. You want a defined period of time. Otherwise, it's an unacceptable condition as far as the vendor is concerned. Just like you test drive a used car to make sure the brakes work. When you're putting an offer in the house, listen, I need 10 days. I'm going to go to the building department. I'm just going to ask, is the city going to let me do what I want to do with this house? Am I going to be able to put that 8-story casino in the backyard? Yes or no? And that is how you can protect your buyer. It might be maybe incomplete. It may not get the job done if, like I say, next week City Council just changes their mind and bans it. But it's as good as it's really going to get from a buyer's point of view when it comes to making future changes to a property. And last but not least, you tell the lawyer, whether it's in the agreement of purchase and sale or not, I'm sending you a referral. We're buying this property. This is what the client wants to do. This is the condition I put in, whatever it is, 10 days on solicitor's review. I need you to do the title and off-title searches in that 10-day solicitor review period. So it's not really about solicitor review of how well the agreement's written. It's about making sure we can do with the property what we want to do next year, 5 years from now. Do the title and off-title searches. Don't wait for the title search date, under the requisition date. And at the end of the day, that's how you're going to protect your clients. I'm a little faster than I kind of anticipated. I don't know. I'm going to check the chat if there's a question. Oh,
I have a feeling, Wesley, that if you want to just open it up for questions, it will easily take up the remaining 10 minutes.
Yeah.
So let's just allow people to ask their questions, and you can be the guru.
All right. And first question, what do the letters CYA stand for? Does anybody not know that? C stands for cover, Y stands for your, and A stands for, you figure that out. All right.
Anyone, feel free to unmute yourself and ask a question, or ask it in the chats as you like.
I saw something pop up in the chat.
There you go. Hi, Wesley. As a listing agent, how do we protect ourselves and sellers who have an illegal unregistered apartment?
Okay. Number 1, communicating in writing. Number 2, a warning to your client that the minute this is on MLS, everyone is going to see that this basement is finished, that this house that used to be a 4-bedroom house is now a 6-bedroom, 4-bathroom, 2-kitchen house. And that once that is public knowledge, they expose themselves to inspections. Inspections lead to work orders. And that they are liable, that if the city comes in, because these work orders can literally be tear out all the drywall so we can inspect the wiring. tear out all the drywall so we can inspect the plumbing. And if there isn't, say, sufficient side yard setback for that side entrance, the city may order you to fill in that side entrance, pull out the basement apartment entirely. And I'm not the one who told you to put the basement apartment in. So all I can do is market what you have, and you get that basically indemnity, disclaimer, basically. Disclaim your liability and warn them that they are exposing themselves to inspection.
I'm going to read the next question just because people who give these things, Wesley, generally have a tendency to just answer the question, and most people listening retrospectively don't have the option of the chat. So I'm going to read this. Are there certain off-title searches that you do on every purchase, or only when you suspect a renovation or multi-units?
Well, in theory, municipal property taxes are an off-title search, and those are done on every file. So you're always asking the other side to provide most recent tax bill. If they won't give it, you have to order a tax certificate. We're looking for leases. So for a period of time, until enough lawyers told me to go satisfy myself, I took it out. But I used to requisition. I used to say, look, send me your most recent gas bill so I can see if there's a furnace lease on there that you haven't told us about. And lawyers just told me to go fly a kite. And I eventually took it off my rec letter, but I used to try. It's worth trying, because people can't get stuck with these, $10,000, $15,000 furnace contracts or hot water heater contracts. And then, they'll have to go to small claims court and fight it out. And no one's happy with that. It's legally, I may have done nothing wrong, but a client who's not happy with the service they provided isn't coming back. So it cost me money either way. My practice, because it doesn't, there's not a lot of automatic off-title searching for, I would say, 90% of my files. It's a lot of condos. Well, status certificate reviews are off-title searches. We do that every day. We have a questionnaire that we send to the clients. And so, I'm trying to answer this question fairly, even though I'm probably spending way too much time on it. So I'm always asking, what do you want to do with this property in the future? And so I'm always looking at budding land searches. I'm always looking for that railway, because I always remember that call I got in that second year, from a litigation perspective. Am I going to be able to put in a pool, or do I back onto the railway? And a lot of it just comes with knowing the neighborhoods. I know where the train tracks are in downtown Brampton, which neighborhoods are directly affected. So, it kind of becomes second nature, those railway warnings. Anything north of Mayfield Road, I'm asking about and warning about, some of the greenbelt protections, and asking specifically, you are aware that the house that you see is the only house that'll ever be on that property, right? That sort of thing. So that's the kind of every file thing, but everything else is kind of based on, the questionnaires and the client intake process as to what it is we're doing on a file.
Okay, what about buying a house with a finished basement with no work permit that is not intended to be used as a separate apartment, but just for your own personal use? Marina has asked that question.
In terms of searches, so all you can do in that situation is you're gonna get your instructions from the client in that situation. You're gonna say, if it's a finished basement, you're probably going to be okay with title insurance. Obviously house inspection, 100%. Because if there is a work order, it's going to be insured at that point. And what you're going to be looking at is the cost of remediation. But we probably should see if there's open permits. And if there's no record of permits, you want to talk to your insurance company about making sure that everything's insured, because if there is a wiring problem and it burned your house down, you don't want your insurance company denying your fire insurance claim. That is in theory, one of the outcomes of turning a blind eye to these issues. But yeah, it's from an off-title searching point of view, it's going to be building, zoning, and getting instructions from the client on accepting title insurance.
All right. Arun asks, can you expound on the name searches for purchasers' names that are similar to others? So same name search, or I guess they're talking about writ searches here, requested by lenders. Why is this necessary?
If you've ever sued somebody, you know that a judgment is worth exactly the cost of the paper that it's written on. If you can't collect, it's worth nothing. So all you do is you go to the local sheriff's office and you say, yep, I sued Wesley Jackson. That jerk owes me $15,000. The sheriff is now aware that I owe this money. And if I ever go to sell land, I can't sell the land without paying the judgment. And that's how the courts, enforce the fact that they've issued this judgment and declared that I owe this money. And so those writs enable, number one, if I'm willing to spend the money, I can actually direct the sheriff. If I know that Wes Jackson owes me money and I know where he lives, I can direct the sheriff to go do a sheriff sale of that house. And that sheriff sale is going to supersede your agreement of purchase and sale. It might supersede, I mean, there's an order of, I won't get into priorities and super priorities and all that stuff, but it can take priority to certain claims. And at the end of the day, you get into fraudulent conveyances. So as a buyer, I just bought off Wesley Jackson. I didn't do any diligence to see if that writ was actually him or not. Well, guess what? That creditor can now attach that writ to me as the buyer. And now I'm paying Wesley Jackson's bills because the creditor knows where my house is and who knows where Wesley Jackson's other assets are. So in order for that judgment not to attach to the land, regardless of who the owner is, you have to do your due diligence. You have to satisfy that search requirement. And if there is a writ, you have to make the right statement so that the writ doesn't attach to the land.
Okay, Vimal asks, how often do you see the city really enforcing illegal builds? This is a good question. I live and work in Brampton as well, and it's an absolute crap show with illegal units in Brampton. I'm glad I'm not answering that one.
Listen, if you have a better system than rolling a pair of dice, then you have a better system than I do. The province complicated things when they basically mandated that all cities have to allow secondary units. And so it really becomes a matter of making sure that the secondary unit you have is lawful in terms of fire, electrical safety, side yard setbacks, having 2 exits, all that stuff. So the city cannot keep up. That's number one. Especially now during COVID. I mean, city council just had a big meeting about the fact that they aren't doing driveway prosecutions at all. And even if they reopened courts tomorrow, 30% of the claims would be dismissed for delay on the first day because they're just so backlogged. So they can't chase them all down. So the city's approach has been, when it comes to our attention, we're going to work with you to bring it into compliance, get it registered, get all your inspections done, because they just can't afford to enforce. Okay, so that's number one. Number two, if you fight with the city when they're trying to work with you, they will eventually drop the hammer and prosecute you. But just like if you ever had a speeding ticket, your first meeting with the prosecutor is, come on, dude, like, let's settle. Sure, you were speeding 180 in a 40 zone, but if you plead to 100, we can wrap this up. And that's going to happen in the building and zoning. I've been there. I've been at, that first meeting with the prosecutor is always a settlement meeting. Yeah, you didn't cooperate with the inspector to bring it into compliance, but here's your next court date. Go bring it into compliance so we can drop the charges or reduce the fine or do whatever we can to clean this backlog out of the court system. Because we just can't afford the justice system. It would be too prohibitively expensive to try and do. So we're really out. I say we as if I talk for the city. I don't talk for the city, but my observation is, the city is trying to shut down the death traps. The one exit, 6-bedroom basement apartment where someone is going to die in a fire one day. Those are the ones they have to focus on, because life is on the line, and it has happened. People have died in these fires, and and I'm not making light of it at all. It's a bit of a brutal situation. But the guys who just didn't file their paperwork or didn't take out a permit, but they've got the records to show that reputable contractors built it. They're going to work with you. They're going to work with you.
Okay, guys, I apologize for this, but we've hit 11 o'clock. Maybe Wesley will be good enough to answer your questions offline. I know he is part of our group and an active contributor. So if you do have any further questions, you might want to post them in our forum. But for now, I'm going to thank Wesley. And, we are all able to see in Wesley's comments someone who is an experienced practitioner, someone who understands their stuff, particularly if you're in areas around Brampton or others, and you are encountering these issues. It pays to go to lawyers who understand their subject matter. Wesley, as I said at the beginning of this, is exactly that. And he is a great example of the assistance that practical lawyers can bring to trouble. And so I would encourage you all to explore him, his firm. Wesley, do you want to leave your contact details for people so that they can reach you, or maybe an email or something, just so that if anyone has any further questions or has any actual legal concerns, they can reach you directly?
Yep. I'll do what I can.
Okay, fantastic. So we'll post it as well when we put this up, which will be available in a couple of hours. Guys, thank you very much as always. Our next presentation topic, just so you're aware, will probably take place next week. I'll be leading it. It's based on the feedback from the sites. We're going to be doing title searching for agents, how you pull title and how to do a cursory overview, not a detailed overview, but a cursory overview, so that you become a bit familiar with the process of listing your properties. For now, Wesley, thank you very much. Thank you for all who attended. Wesley, I know you don't know this because you probably weren't looking at participant numbers as you were going, but we broached over 120 people at one point in the discussion, which means that we'll have about 250 people watch us within 24 hours and then continually watch it thereafter. So thank you very much for everything, and thank you for all who attended today.
Thank you, everybody.